Good morning, good afternoon, and good evening to all of you who join us from around the world. My name is Bjorn Otto. I'm the chair of the IPBA's Employment and Immigration Law Committee, and I have the pleasure of welcoming you to our summer webinar, Coldplaying HR Policy When Concert Cuddles Become Compliance Crisis. Well, until a few weeks ago, Coldplay was just a music band, and now the term has become synonymous for being exposed to doing something you shouldn't. The concert and its surroundings has not only attracted tabloid and social media interest, but raises also a number of legal questions. And today's panel will take a closer look at them. Chaired by Leslie Ligorna of Morgan Lewis, Tokyo, Carolyn Knox of Ogletrees in San Francisco, Vivek Daswani of V Law Partners in Mumbai, Alberto De Luca of DL Law in Milan, and Clevar Venditti of Matos Filhos Avogados in Sao Paulo will fill us in the do's and don'ts of concert dating. I hand over to you, Leslie, to guide us through today's webinar and the discussions. The floor is all yours.
Thank you, Bjorn. And thank you, everyone, for joining us, whether it's your morning, your afternoon, or your evening. Welcome. I'm going to provide a brief introduction for all of you, followed by a brief summary of the basic facts that the CEO of Astronomer was caught on the Jumbotron with his arms around the company's chief people officer. The couple quickly separated, as you probably saw. Most people have seen this video. Millions of people have seen it. And they tried to hide their faces when they realized they were caught on the big screen. And within days, the CEO and the chief people officer resigned from the company as a result of that incident. The company then released this statement, quote, "Astronomer is committed to the values and culture that have guided us since our founding." And it went on to say, "Our leaders are expected to set the standard in both conduct and accountability, and recently that standard was not met." So as a threshold issue, Carolyn, I'd like to turn to you. What is the crux of that issue here from a US employment perspective? I mean, people date coworkers, and they don't always have to leave the company. And that, of course, wasn't the case here.
True. There's no US law that actually prohibits workplace romantic relationships. The issue is what happens if it's not consensual or it impacts a company's image. It impacts their culture, morale, kind of the power dynamics within the organization. Particularly here, you had a CEO and the chief people officer who are in a relationship when both are married. I mean, that's a PR nightmare. And I think Astronomer actually handled this better than pretty much any other company I've seen. They came right out and said, this is not, we don't endorse this behavior. We're putting them on leave immediately, and we're conducting an internal investigation. I mean, obviously the outcome was going to be what it was because they had actually created such a furor for Astronomer, but it actually put them on a map from a company perspective. So there was a lot of benefit to them, but nobody wants to go through that, right? So let's go back to what the implications are. Companies shouldn't be, the morality police, for example, because Leslie, you're right. People do often meet in the workplace, date in the workplace, and end up getting married. The issue is, how do you manage the implications of a workplace relationship, especially if there is a power dynamic? If someone in a more senior position is dating someone in a more junior position, or they have influence over the terms and conditions of employment for that person, that is where harassment and discrimination laws come in. Relationships often go bad, or maybe not so bad, but then the end of the relationship either could result in real legal risk for the company, or as I've seen, individuals leverage the end of that relationship as a threat to negotiate an exit settlement. But there is extreme impact on the company when a senior executive is known to be having an affair with someone within the company, or a relationship. It doesn't have to be an affair. So what do you do as company management Leslie called it a kiss and tell contract. We tend to call it love contracts, and that's even a misnomer. Um, I usually recommend a company decide whether or not they want to address it at all. And if they don't, they need to beef up their code of conduct, code of ethics, harassment policies to imply that there should be some controls around these relationships, but also family relationships, siblings, spouses, cousins, etc. But under these love contracts, typically someone in a more senior position is required to report to human resources or the CEO or someone in charge. Usually it's the head of HR, which is so ironic in this case, that there is a relationship, and typically there's a meeting with both parties to ensure that it's a consensual relationship, that there are no power dynamics, there is no undue influence on the person in at the junior level, and they sign a piece of paper saying this is consensual and we've notified HR. Then when things go wrong, if they do, then the company has some cover, and can more easily manage the situation. But usually if it's a direct reporting relationship, someone has to be moved. And companies often make the mistake of always moving the junior person, who typically is a woman, which gives rise to a retaliation claim, a discrimination claim, etc. So there are lots of areas a company can get in trouble, in the US specifically, but that's really the major issue, is a harassment retaliation um, situation.
Thanks, Carolyn. And that, was a great summary from the US perspective. And while, a love contract, as you called it, or a kiss and tell policy is common and generally enforceable in the US, are they widely used, or can they be used in other jurisdictions? So I'm going to start with Kleber. In Brazil, what's the situation there?
Okay, so Leslie, first I would like to make two, disclosure here. First, I mean, we are Brazilians, right? So we love to kiss each other, we love hugs and so on. So, and the second disclaimer would be that people dating at work in Brazil is not exactly breaking news, right? So, I mean, the same way Carolyn mentioned, we have relationships wherever we are, right? So this is not a problem, but the real problem seems that when a relationship leads to favoritism or misuse of power or harm the company image, then the company have a problem. Otherwise, I mean, in Brazil, consensual relationships are not forbidden, and there is no law allowing or forbidding this type of policy. To answer your question, I mean, kiss and tell policies are not very common in Brazil, really. I mean, we can find them, especially when we look at the multinational companies, American companies, European companies investing in Brazil. So they have or they import this type of policies and they implement here in Brazil. But for Brazilian companies, this is not very common. But they are not legal either. So companies can implement them, especially, as I said, to avoid conflict of interests or claims of harassment. Um, However, enforcement is tricky, Leslie. And why? Because in Brazil, you can terminate people without providing any reason. So you can just say that you are terminating, I mean, the couple or one of them just because you want to do. And it should not create any issue. However, if you, for example, decide as a company to terminate one of them or two of them for cause, then it could create a risk, right? In this case, the companies may face claims seeking moral damages. And in a worst case scenario, they could, for example, face collective claims filed by unions or by the labor prosecutor office, try to challenging this type of policies implemented by the company. So, in my opinion, I mean, the best approach is to require disclosure only when there is a direct report or risk to the company, not for example, every romance that you have in the workplace.
And can I ask if someone is moved, if it's a subordinate superior relationship, and if the subordinate is moved, does that give rise to any claim for the subordinate in the relationship?
It could depend on the circumstances, of course, but it could create an issue, especially, I mean, if the company actually moved the person, I mean, by its own decision without having a conversation, without having an agreement. So it could trigger an issue, yes.
Great, thank you. And so as we head east, turning to the EU, what's the concern with this type of policy, a love contract in Italy? Alberto?
Thanks, Leslie. I need to make a preamble myself because I met my wife at work, so I mean, I can witness what happens. It went well. It went well in my case. But anyway, there wasn't a policy back then at the firm I was working for. Basically, the two aspects which need to be taken into account when kiss and tell policies come in are, on one hand, of course, compliance and privacy, because there is a limit beyond which people might not be forced to give information they don't want to give. Actually, here is about the balance between what is the interest which is intended to prevail, business-wise, of course. So, in a nutshell, and the other aspect which needs to be concerned is whether these kind of policies can in any way be implemented, irrespective of their enforceability, and what the consequences could be. On general principle, I wouldn't say that. And by the way, we have been in a similar situation with Caroline in a very interesting case we followed together for an Italian manager whose company had been acquired by a US corporation. And the US corporation had a global policy, let's say a kiss and tell one. But we'll get back to it in a minute and we can describe how it went. Basically, there is no particular concern on the possibility to draft and put in place, publish, have signed all the kiss and tell policies, which are deemed appropriate to serve the business purpose. Also because there is a clear interest underneath, which is, of course, to preserve the correctness, fairness of the treatments between colleagues, reporting lines, career paths, decision-making on salary increases and career progresses, which might be influenced or damaged in case there is a relation capable of influencing the objectivity that, for example, a manager needs to have with the reporting lines, irrespective of any personal relation. So there is a reason, a legal reason which justifies the existence of this policy. But for the aspects I was mentioning a minute ago, there might be big issues or expected issues when enforcing these policies, because of course, from a privacy standpoint, we are going beyond the line of disclosing personal information, which to a certain degree may or may not be protected by privacy law. Considering that, of course, at stake are two opposed interests, and then we need to balance what is the one prevailing. And we can also tell that in certain circumstances, the business purpose is intended to prevail. But on the other hand, and this is one aspect we have carefully analyzed with Caroline back then on that case, disclosing and being held to disclose this kind of relations gives access to the company to very sensitive information about sexual orientation. Maybe also this is related also to what happened at the Coldplay concert. Let's say hidden relations which are supposed to stay hidden. Otherwise, there would be the situation in which a lot of people at work knows what the wife or husband doesn't know, and which would be, I mean, at least inappropriate, leaving for a moment the legal perspective. So, and this is exactly the point, the knot we had to untie with Caroline, which is, and was pretty much the case, how the manager was held to comply to the policy, and third point, and then on down, what the consequences of not complying would be. And here we can analyze the situation divided in two, because if on one hand, a corporation may try to enforce it anyway, on the other, the manager and the other employee may have opposed a decision to dismiss them, for example, for cause for having breached the policy, saying that it was discriminatory, for example. Coming to obstacle the continuation of employment for employees due to the fact they have personal relations. And then we go back again to the need of balancing what is prevailing between the business purpose and the individual right. In the end, and we advised the client to disclose properly, so with a very privileged communication channel with the global HR one-to-one. And then there was a happy ending, because even though disclosure was not particularly timely, then it has been accepted, appreciated, the disclosure, of course. And the less interesting part of the story was, or happy and part of the story is that the other employee has been moved to another function. And then this means that anyway, the situation is a practical impact which cannot be avoided, has one way or another obstacled the career path in place, the perspective that the other employee may had before such disclosure. So this was no zero impact anyway, but the enforceability aspect remains. So in a nutshell, from a EU perspective, enforceability, in particular Italian one, enforceability may not be as easy than it seems.
Thank you for that. I want to hear more about that case. I know you'll get to that. Continuing east, Vivek, in India, can an employer implement an enforceable kiss and tell policy?
Well, now, India, if you look at what's happened over 2 decades, what used to be like a 500 employees would be a large company. Today, even a 50,000 employee company is considered as a small company. So, generally 600,000, 700,000 is very common to hear that's the employee strength in India. So to have this kind of a policy really the companies were not able to hire anyone, But, we don't call it kiss and tell policies, because I guess I wouldn't be surprised if many Indians interpret it literally. But the way we normally, it's pretty common to have fraternization and disclosure policy. That's what is generally termed as. And that's pretty common now. When it started about 2 decades back, we did come across handbooks and policies which prohibited this kind of relationships and gave the right to the employer to actually terminate employment if they were having an affair, basically either accept resignation. But that has evolved. In fact, those matters did go to court several times, and that kind of a restrictive covenant, what we called it, was considered to be arbitrary and unreasonable, and it did not stand the test of the court. So now what I said is we have the disclosure policies, and again, those disclosure policies, generally, the 3 test principles are pretty similar to what all the other panelists have spoken. It's whether it really affects the integrity of the reporting lines, whether it creates a conflict of interest, whether it affects workplace morale, and whether it creates any doubt of bias and favoritism. So I think those are generally the principles and guidelines. I would say internationally it would be adopted, and I think Indian courts are also looking at it in the same way. So I don't think it's bad in law to prohibit it, to have that kind of a restrictive covenant with respect if it affects literally these 4 points which I told you. We have for government employees, again, we have central government service rules, and in fact, there you have in professional conduct that your behavior should not be that of unbecoming of a government servant. So if I were to put this present scenario of astronomer in and if it was a government employee in India, I would think this would squarely fall within the test that it's unbecoming of a government servant. But of course, yeah, the standards are much higher with respect to senior management. And the courts have really, of late, if it really affects, there's an apparent conflict of interest. And looking at the present case, I think it actually ticks all the check boxes. There is, the reporting line is affected, the company morale is affected, and also there's a risk of bias. So I think as far as India is concerned, this would all be valid grounds. I have another twist to this, when I've been reading about all this and they say, okay, both the guys, Andy and whoever, they resigned. But the question here is, why was the resignation accepted? Ideally, if it was termination for cause, that would actually be setting an example. Because by accepting the resignation, in a way, what you're doing, for example, if you have certain benefits which you're entitled to if you resign, but you're not entitled to if you're terminated for cause. So is really accepting the resignation a punishment and an outcome, or is the company really, and it's just trying to give a sweet handshake to the person's concerned? So that's another twist to the case here.
It probably comes down to the question, what is the appropriate punishment, as you may call it, because I assume he resigned in order to protect variable remuneration and not to be considered a bad leaver. So he probably wanted to avoid being terminated by the company, if you're alluding to the specific case. And maybe you could also argue that punishment already was in the fact that he lost his job.
Hey,
Carolyn?
I would posit that they permitted him to resign, but I would posit that he walked away from his unvested equity, et cetera, and they had just gone through $93 million Series D funding round with some very high profile venture firms. So yeah, I don't think that he walked away with anything. And I wanted to alert you, I just clicked into a gossipy website that we get, we get the email every morning. It's called Above the Law. And apparently, don't know if this is true, but apparently Andy Byron, the CEO, is considering filing a defamation lawsuit against Coldplay.
Yes,
Not a good
Yeah.
idea. Not a good idea.
Is that legal advice?
Yeah, well, apparently not taking any good legal advice. So don't know if it's true. I'm reading it in Above the Law, so who knows, but.
Yeah, I think the argument is that the Coldplay singer just draw the attention to them by saying, "Oh, are they just shy or are they having an affair?" So
Right.
Yeah, I mean, they
Not
exposed,
knowing you hit the nail on the head. Yeah.
yeah, they were in a public forum.
Yeah.
And he didn't know who they were, and that, defamation,
Yeah.
you have to prove certain factors, and I don't think he's ever going to get there, but.
Yeah. So drawing on that, Bjorn, the next question's for you. We heard about the issues in Italy from an EU perspective, but what about in Germany? Can an employer hold the company executives to a higher standard and prohibit them from dating subordinates, or can the employer incorporate these restrictions in the employment contracts for their senior execs?
Yeah, similar difficult as it is in Italy. What we're seeing in Germany, I think that is true for most of Europe. There's more of a laissez-faire attitude, so or maybe more love-friendly attitude. We're seeing a lot of these policies, and I assume it's fair to say that originally that was mostly U.S. influence, or it came over the pond from the U.S. And like some years ago, all these policies were very strict and forbade having love relations at the office. This, at least that is my perception, has changed gradually, going more to a reveal policy. You need to you tell if you're having an affair or in a relationship, and that is regardless of whether it's man, woman, 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 man, man, whatever. But it's very difficult to enforce these policies. So it's more like giving employees guidance what the business expects them to do, even though if there's non-compliance, it is very difficult to use this, for example, as a fair ground to dismiss an employee just because he fell in love with someone or was having an affair. So there's no real distinction between like saying, well, the good affair that results in a marriage at the end of the day and the bad affair that's a side hustle. But it's, yeah, general rule, I would say, very difficult to enforce. And in Germany, on top of that, you also have this works council co-determination aspect, so that you need to negotiate code of conducts which try to regulate the way people interact at the workplace, that's subject to a works council co-determination.
So it's interesting. It's interesting to hear from the common law jurisdictions that you're all coming from. Just very briefly, from China, where it is code, employers can implement their own policies as long as they go through the consultation process. And in this case, if they had that policy and the executive signed on to it, theoretically, he could be terminated for violating the policy or encouraged to resign, which, to Vivek's point, we do a lot of that in China, is encourage people to resign in order to avoid the potential risk with respect to a for-cause termination and the bias in terms of sustaining a for-cause termination. So
I mean, that is similar in Europe, because looking at it from a formal point of view, it would be a breach of contract if you agreed to the code of conduct up front. But as always, the devil's in the detail, and courts would look into like, yeah, what the individual circumstances were, and
got it. So we started, Bjorn, you started, or I asked you to differentiate between the standard for for a senior executive. So on that same topic, I'm curious, can the employment contracts for senior executives override or modify statutory protections like freedom of association and privacy that you've mentioned? So Clever, what about in Brazil? If there's a conflict between the contractual terms for a senior executive and the employment laws, what's going to prevail?
Well, the law will always prevail, Leslie. I mean, in Brazil, constitutional rights are like a holy grail, right? So employment contracts cannot override them. So if there is a conflict, the law always prevail, as I said. For example, you cannot waive rights like severance pay, notice period, protection against unfair dismissal, and why? Because these rights, these employment rights, are in the same constitutional level, such as privacy and practice against discrimination. So you cannot override them by contract. The only exception, I mean, and this is not the case, of course, but the only exception is if the contract gives more rights than the law, which is always welcome, of course. But when it happens, senior employees may negotiate different circumstances or conditions in their employment agreements. But when we are talking about constitutional rights, no way to negotiate.
Interesting. Alberto? Can a senior executive contract override not necessarily constitutional rights, but statutory rights?
It's exactly as in Brazil. Because also in our case, law, the contract cannot provide restrictions to what is allowed by the law. And here, also in Italy, we are in an environment in which constitutional rights are at stake. So I conclude that law is intended to prevail, as in Brazil, unless the contract provides more rights, more wider, let's say, protection for the employee and even for a senior executive. But the workaround here could be to regulate in an employment contract certain consequences, allowing to have. I'm thinking of finding a way to have leadership clauses or define the circumstances under which the employee may have access to certain, to certain contractual obligations or not. Of course, this is a very sensitive topic again, so it could be a way to achieve some of the restrictions we may want to put in place following another path. But basically, law cannot be, these kind of rights cannot be limited with contractual provisions in Italy as well.
Great. Interesting. India, Vivek?
Well, in
What's the
India,
position there?
the line gets a little blurry when you're asking a question whether the statutory provisions will prevail or the contract will prevail. Now, the thumb rule, of course, is that the law prevails over contract. That goes without saying. But where the line gets blurry is that we have two categories. The whole labor law divides the employees into two categories of workmen and non-workmen. As far as workmen category are concerned, they are under heavy scrutiny, legal review, as well as the statutory provisions regulate them quite a lot. But once it comes to senior management, they are outside the purview of most of the statutory provisions and they are governed by contract. And that being so, then it's just the basic principles of contract, that it's a lawful contract, it's not overly oppressive or violative of fundamental rights. So those basic ingredients of contract should come in. But otherwise, the legal review is quite limited when it comes to senior management. To put facts into the present case, if these two employees would fall within the definition of workmen in India, it would be very difficult to terminate them without, again, going through the whole disciplinary proceedings and establishing a misconduct and pointing out the provisions of the handbook and the code of conduct which were breached. But if they are senior level, as it is in the present case, the contract would prevail, and generally the contracts for senior employees do have a hire and fire policy, which is not permitted for the other employees. And you would generally be governed by the contract and you could fire. And that's where, again, I'm repeating my previous point, where this contract is quite elaborate on what happens when an employee resigns, when there's a breach of contract, and in the circumstances that he leaves. So that's generally the perspective in India.
Great, thanks. And Bjorn, Germany, is it the same as what we've heard for Italy and Brazil?
Yeah, well, if you look at the relation between contract regulations and the law, the general principle in Germany is like it supersedes what is more beneficial for the employee. So it can be either the law or the contract. But as I said before, when it comes to these codes of conducts, non-compliance in terms of relationships at the office typically do not qualify as a fair reason for terminating employment, but it's more like a guidance for the people to show them what is expected from the company. And at the end of the day, quite often you achieve a similar result because non-compliance, as you mentioned before, also quite often results in compliance investigations, and yeah, these can become embarrassing for the people. So at the end of the day, to avoid all these processes, a lot of people resign if they're charged with any of these behaviors.
Great, thanks. And Carolyn, even in the US where contracts are used with senior executives, what would be the position if there is a conflict with the employment laws?
I've been sitting here trying to think about what conflict there could be with the employment laws. We're a common law jurisdiction. We're one of the few jurisdictions in the world with at-will employment, although executives do have contracts, but they all have for-cause termination. They all have clauses that require them to follow the code of ethics, code of conduct. If they don't, the company's in trouble. And so generally you're going to always be pointing to company policies, and the violation of the policies is the basis for a termination. And those policies are going to be consistent with US law, in particular Title VII, which is the anti-harassment, anti-discrimination federal statute, and then state statutes, which I sit in California, and the California statutes are actually quite a bit more restrictive than the federal statutes. But it does come down to whether or not there was a policy violation. I've done several investigations into these, and I'm able to link the termination to a policy and the failure to follow the policy. Whether I agreed with the policy or not is irrelevant.
Yeah.
But senior executives are on notice that they need to follow the policies. And if they're going to engage in behavior that's risky for the company, they have a fiduciary duty to the company to behave in a way that does not put the company at risk. So I don't have any sympathy for people who violate this policy. All they have to do is disclose to the senior HR executive that, unless it is a senior
Maybe
HR
he did.
executive, and there are policies that do put a higher standard on people in HR or the C-suite with regard to this. But if you know the policies there, the problem is people don't read the policies. But
Yeah.
people sign that they've read and agreed to comply with the policy. And that's how they create their own nightmare. But I think it's important to emphasize that senior executives have a fiduciary duty to protect the company. And by engaging in this risky behavior, if it's an affair, if it's a workplace relationship, they all know, particularly if they can influence the terms and conditions of employment of individuals within their company. They know they're creating legal risk.
Yeah.
Of course, human emotion takes over and people don't always think clearly, but that's why these policies are there to protect the company.
In this respect, Caroline, one question, if I may ask. You mentioned that it is about protecting the company, and if you look at Astronomer, this specific Coldplay incident, at the end of the day, or at least looking in hindsight, really put them on the map. I assume at least I
Absolutely.
didn't know the company before, and probably it was one of the best promotion they could get. And I just read today that they also hired Gwyneth Paltrow,
Yeah.
the ex-girlfriend or wife of the Coldplay singer.
Yeah.
And you can see the ad on YouTube. So for them, I assume it was no real damage, but it was more, yeah, to a certain extent beneficial.
Yeah, but Bjorn, and yes, absolutely. And that's why I said at the beginning, I think they did everything right here.
Yeah.
Including hiring a crisis communications firm that's very, very clever, that immediately put that out. I think
Yeah.
they leveraged an incident that they wouldn't have invited, but if they had reacted differently, it could have damaged the company
Yeah.
significantly. And in fact, the fact that the chief people officer didn't immediately resign was shocking to me. On the other hand, I guess it was 2 to 3 years ago, there was a string of high profile resignations and terminations from very large US companies as a result of workplace relationships. Some affairs, some not affairs, some just voluntary, both single, etc. Those people all lost their jobs, and the companies had to crawl out of some pretty negative publicity, particularly McDonald's. So there is a lot of negative publicity that comes with the high profile workplace relationships where, especially where something goes wrong or someone alleges that they were disadvantaged by advantages given to someone in a relationship with a senior executive, or it doesn't even have to be a senior executive, just a manager. Because in the US, you can sue if you're impacted by a relationship. So
Thanks. So along those lines, I'd like to talk a little bit about, that the company's immediate reaction that you mentioned was to announce that there would be an investigation. What would you advise the company to do if this was your client in Brazil, Kleber?
Well, that's a 1 million question, right? I mean, if my first reaction would say to the company, don't panic. I mean, right? So the company maybe should investigate the facts to check if any policies were breached or if there was any misconduct there. I mean, transparency is key, I believe, but respecting privacy as well, right? So if the relationship didn't affect the company, which seems to be the case here, or the relationship didn't break any rules, maybe a gentle reminder about professional conduct would be enough. But if there was a real problem, such as favoritism or damages reputation of the company, then maybe moving the employees to other positions or terminating them with or without cause would be I mean, something that the company could think about it. But I mean, all depends on the facts, right? I mean, Leslie, it's hard to I mean to say something without knowing details if there was favoritism or not, and the impacts of their conducts. As Carolyn said, I mean, maybe a statement, a public statement such as they did, it would be advisable. But once again, I mean, depends on the facts. I would not recommend anything without, I mean, have all the details of the case, especially the result of an investigation to see if there was or not favoritism. Just to tell you, I mean, it's a fun fact, but 2 months ago, I worked in a similar case involving a big law firm here in Brazil. There was not a scandal, but two partners of the same practice were in a relationship, and they didn't disclose this in the beginning. But after, I mean, some people have some suspicions about them, then they decided to disclosure. And what this law firm did, they I mean, have a very clear conversation with both partners, and the law firm asked them to decide which one will leave the firm in the end of the third quarter, so by September of this year. So they have to decide. One of them must leave the company. And I don't know if it was a smart decision or not. I'm assessing this, but I'm pretty sure that this was not good for the relationship, right? Because they are now fighting to see which one will leave the firm. But I mean, this is all about the facts, right? I mean, you have to consider the size of the company, the impacts of that relationship, and so on.
I completely agree. And I think one of the things that hasn't come out is the culture in the company when the head of HR is dating the CEO. Like, could anyone bring anything really to her if she's, having an affair that was well known in the company? I mean, I think that's really from the outside, though, and we have a question from the audience that, astronomer turned this incident into a PR boosting event and capitalized on the attention, resulting in a 15,000% spike in visits to their website. The question is, what can we learn from this approach to make lemonade out of lemons, and how might it affect future HR policies and responses? So, Kleber, I think you responded a little bit that way. Does someone else want to answer that? Take
Oh, go ahead,
Vivek.
So, I'm like, we've already reached out to clients, and some clients have reached out to us to already have a crisis communication policy in place. So that's one thing which is happening. I totally agree with Carolyn that, what the astronomer did was perfect, because, just you asked a question to Pepper what he would advise the client. And I think that's exactly because the employment contract between employer and employee still continues. And the employer is still obligated to maintain the privacy and dignity of its employees. So the best thing you can do is just stick to the facts and avoid any speculative or accusatory comments. And that's what astronomer did. And I think that I think would survive probably in any jurisdiction. With respect to what the company should do, I think this is a wake-up call for companies to have, like what we are going around, asking companies to check if they do have a crisis communication policy and how they should react, and what should be spoken and what should not be spoken. Maybe again, the fraternization and the disclosure policies need to be relooked at and maybe tightened a little bit more on the disclosure. And maybe, I don't know, it's some of the clients are actually even reaching out to carry out internal investigations to check and get facts and figures out on how many such disclosures have been made and how many such have not been made, which they're aware of. So I think this kind of incident, it's flared up more than it should, but it kind of opened the eyes to kind of figure out in the future how these kind of crises should be addressed.
Excellent. I think, Carolyn, you had your hand up.
Yeah, I do want to remind everyone that this was an extremely unusual event, right? This is not your norm, but it just made it really fun for everyone. So astronomer had to take certain steps, and they could take certain steps because these two were out in public, in a public forum. So usually you're not going to run into that. So should a company make a statement? Not unless you're caught on a jumbotron or something very, very obvious, right? So it should remain private. It should remain confidential. But a company in the US and around the world does take typically these things very seriously because of the potential legal risk. And there is a huge difference between civil law and common law countries, well, at least the US and everyone else, on what damages are available if someone sues for harassment or retaliation and wins. We're talking often in the millions of dollars, and the cost of even getting to trial is several $100,000. So it's a very expensive proposition to get wrong. So managing your workplace, and to Vivek's point, making sure that our clients have the right policies in place, policies that reflect their culture. Not everyone wants a love contract, but making sure they have a code of conduct or code of ethics, which holds senior leadership to a higher standard, for example, making sure they're doing the training. In the US, in multiple states, it's mandatory for employers to train senior management, more rank and file employees on harassment, and cover these issues. Make sure they cover workplace relationships during these trainings. So I think that's super critical, but not every situation is going to be public like this one.
Very true. I think we have time for a couple more questions. If anyone wants to put any questions in the Q&A, we're happy to take them. But separately, I'd like to ask Vivek, when someone resigns from a senior position, and we talked a little bit about, they might be walking away from a lot financially. What do you think that, the individual would be facing here? Might they be facing, complete forfeiture of all of their equity? Is it just unvested? Does it matter if it's, and you briefly alluded to this, if it's, a resignation under pressure, or if it's a termination with cause? What do you, callback provisions, where it's a senior executive and it causes damage, whereas we discussed here, it hasn't. What do you think might be the ramifications?
You see, India, it's quite common to provide, for a lot of startup companies, for a lot of investor-run companies, it is quite common to have a low take-home package, but a lot more as incentives. It could be ESOPs, it could be phantom shares, it could be company performance-linked bonuses, individual performance-linked bonuses, team performance-linked bonuses. As far as listed companies in India goes, we have separate guidelines with respect to these kind of options which are provided. And generally, the way they are structured is if an employee is terminated for misconduct, he loses out these options and benefits. On the other hand, if he resigns, whatever options have been vested, whatever phantom shares and benefits have been vested, or proportionate to the time up to the time he was employed, based on the valuations and income of the company, he's entitled to those benefits. So that's why at the start, I did mention that I don't know whether resignation is really setting the right precedent for the company, or whether we don't know his employment contract, but I'm sure a person at the level of CEO would still have a lot of benefits and perks linked to his performance and the performance of the company. And I think, as far as India is concerned, it's quite common to have those. And this kind of an incident would, again, if it's an investor-run company, the chances are very high that they would say, we're not accepting the resignation, we're terminating because obviously you don't want to pay out. If it's a startup company, again, the same reason, you may not want to go through those payouts thing. And of course, suspension is fine, but yeah. So I think, and I don't know about other jurisdictions, but here a lot of it is linked, and also the termination. I may just add one more point is the reason for termination here could be loss of confidence as well, and that's, again, though it's a very subjective point, it is recognized. And and loss of confidence when you're talking about it's again, the test that is that person holding a position of power, is that person abuse that power, and does it mandate the company to kind of take coercive action against the employee? I think all those check boxes are ticked, and a loss of confidence could be a ground to terminate for this level employee on misconduct and losing those benefits.
It sounds almost like the loss of confidence might be similar to the fiduciary duty in the US.
Exactly, it's very similar.
Okay. Is it codified, or how is it? Is it just in common law, or where does one find that loss of confidence?
There's Supreme Court judgments. Even if you Google it, you'll find the matters have reached the Supreme Court of India as well. And as I said, the three main tests, in fact, there's an overreaching test also, because a loss of confidence cannot be the subjective opinion of the management. It has to be objectively quantified and substantiated that it results in a loss to the company. So, courts have, like as I said, the three tests is, whether the person was holding a position of power, whether he has abused that power, and would that, is the reason good enough for the company to terminate his services, because it's just not inconvenience, but it actually determines the company's organization's whole setup. And once those three check boxes are ticked, then the overreaching condition is it the subjective opinion of the management, or are there objective, quantifiable reasons to come to that conclusion? So it's not codified as such, but common law principle, again, recognized by courts.
Got it. So I'm curious, Bjorn and Alberto, in the EU, is there that concept of the loss that you could terminate based on loss of confidence or breach of fiduciary duty, where someone has basically had an affair, in this way? Do you think that it would hold up, or is there anything like that in your jurisdictions?
You go ahead, or I do, Bjorn?
Please go ahead, Alberto.
Actually, yes. And this is a perspective which may have become relevant due to the positions held by these two persons here, which is linked to what Caroline was saying a few minutes ago. Because considering anyway the limits to enforceability, violation of very private information and so on, we're talking about very, very senior and top level executives in the company, causing damages to the reputation, or risking to cause damages to the reputation, to the clean organization of the company, the possibility to manage people properly. The same, given that it might not be enforced, but it can be implemented, a kiss and tell policy, preventing that kiss and tell policy to work, and this undermining the correctness of the working organization. All these things put together can impact the fiduciary trust between the employer, the company, and these two executives. So it may have a relevance. The point, again, is that it would be a very risky termination for cause for both of them, implying maybe more tricky for the HR manager, because directors and CEOs, all the different contractual positions in our jurisdiction, but I won't go into much details with that. But definitely it is a principle existing under the law. It may, what I would do if a client asked me guidance in a situation like this was to, of course, see what is the aim of the company, which in this case would be to, remove people breaching this policy. And among the aspect, the solutions I may propose would necessarily exist, the one of leveraging on the breach of the fiduciary link, which needs to exist with these very senior positions in the organization. And I would also believe that we would have a chance in court to bring it along. And in respect to what Kleber was saying a while ago, also triggering an investigation to see whether anything has been managed properly or has been badly influenced by these relations would be a good angle to approach this situation. But anyway, we could, on one hand, find something and then object disciplinary relevant behavior, or putting a question mark on the trust that we may have on the HR manager and the CEO on the correctness by which they do their job. And this would be another angle by which we may achieve termination anyway, following, of course, the client's will.
Yeah, I think it's a similar situation in Germany. Typically, you would distinguish between directors or CEOs and regular employees who have a stronger protection against dismissals, but also in Germany, you know this concept of fiduciary duties, and depending on the details of the case, that may have relevance and ease the process. So that is why one of the takeaways of our today's discussion to me is that no matter which parts of a code of conduct or a contract are at the end of the day fully enforceable, it still seems to be best practice around the globe to have such contracts and or code of conducts in order to provide a regulatory framework to both executives but also employees what a company expect them to do or not to do to provide some guidance, and I think that is an important aspect.
You took the words right out of my mouth. I was going to leave off with the fact that it does seem like in every jurisdiction there should be something that sets out what the company's standards and values are, so at least you can hold your senior executives to that, if not your rank and file employees as well. That leaves us with about a minute left. I don't see any further questions. I would like to thank you all so much for sharing the lessons and the issues from your jurisdictions. This has been very informative for me, and I hope for everyone in the audience. Thank you very much for joining us this morning, this evening, or this afternoon. Have a great day.
Thank you all.
Thank you.
Thank you.
Thank you all. Bye, everybody.